Hello, my name is Andrew Flushy. I'm a Virginia traffic and DUI attorney. One question that comes up a lot and I've talked about and written about before is, does it matter that the officer didn't read me my Miranda rights? And unfortunately, in many traffic and DUI cases, the answer is no. It doesn't matter that you weren't read your Miranda rights. The key points for even a DUI case are that the officer has to be able to prove that they had a valid reason to pull you over. They have to prove that they had probable cause to arrest you, and then typically they're going to admit a breath or blood certificate to prove that your blood alcohol concentration was above the legal limit. And usually your statements that you might make after you're in handcuffs, you're really not even needed for most DUI cases. And that's what Miranda is concerned about. Your Miranda rights are really concerned about statements that you make during a custodial interrogation. So when you're being asked questions when you're in police custody, that's what Miranda is concerned about. And so if you don't make statements, then it's not really an issue. You may make statements, but they may not need them in court. And so that's the thing we have to look at anytime there's an issue about Miranda is, were you actually in custody? Were you being interrogated? And did you make statements that the Commonwealth needs for their case? Now, if you did make statements that they need and you were under custodial interrogation and Miranda wasn't read, then it really does matter. Now, if that sounds really complicated, it's because it is, but this is definitely something to talk to an attorney about. I love answering the question about your Miranda rights because it shows that the person I'm talking to, has done a little homework, kind of knows, what issues to look for. Unfortunately, usually the answer is that it doesn't matter. But definitely talk to an attorney for your unique case to see if it does matter for you, and maybe it could be a defense.